2011, so only 5% of batteries are recycled. But actually, recycling lithium batteries is extremely widespread and is almost universal, which means that the lithium you pull out of the ground goes on being a battery forever. So, yes. Exactly. The same with chips where, what about? Two, 1, 2, 1, 2. What's the sound man's favourite day of the year? It's the 12th of December, because that day is 1212. Well, that put everyone quiet.
Can we check all three of the mics?
Testing. I don't have anything as original as.
Yeah, sorry. It's a sound man joke, though. It's very, very niche audience.
I have too little material like that to use before the event begins.
Okay.
Well, brilliant. I think if that's everything, happy to make a start. Thank you so much for joining us on our third panel of the day. So I thought I'd just start with a little story. A couple of weeks ago, Leo, one of the fantastic organisers of this event, called me up and he was like, "I'd like you to moderate a panel." And I was like, "Sure, what do you want it to be called?" And he said, "AI and Us. How policy can help us live with AI." And I said, "Well, do you think you could be slightly less specific?" And he was like, "Sure, no problem. What I'm looking for is a tight 50 minutes on existential risk, everyday inconveniences, chatbots, warfare, Elon Musk, epistemology, and legal philosophy, and the last 30 years of regulation, with a little bit of time for questions at the end." And so I said to him, "Sure, but you better have a bloody good panel in mind." And I'm delighted to say today that we do. So I think we'll get straight into it, just to introduce you to the people beside me. On the far left, we've got Tom Standage. So Tom is a deputy editor of The Economist and its main commentator on AI. He's also the author of 7 history books and takes a particular interest in technology's social and historical impact. He studied engineering and computer science at Oxford. To his right is Gareth Kristensen. He is a partner at the international law firm Cleary Gottlieb, where his practice focuses on intellectual property, technology, and data matters. He advises many of the leading technology, media, and computing groups on AI issues, ranging from IP ownership, licensing, and infringement to engagement with regulators on AI regulation, such as the EU AI Act. And then last but not least, we've got Dr. Thomas D. Grant, has been a fellow of the Lauterpacht Center for International Law and Wolfson College since 2002. He's written on AI and law, among other topics. From 2019 to 2021, he served as senior advisor for strategic planning in the office of the US State Department, responsible for weapons of mass destruction and advanced conventional weapons. He also advises technology companies on issues around intellectual property, regulatory compliance, and litigation strategy. Finally, my name is Eddie Kembry. I'm a postgraduate researcher with the Centre of the Future Intelligence here at Cambridge, and I'll be your moderator for this evening. So just to start us off, I know we've had a number of panels by now, and each of them has tried to deconstruct what AI means in a different way. And having talked to the panelists here tonight a bit beforehand, we sort of agreed on this notion that's often talked about in terms of the AI triad. That is, all sophisticated, state-of-the-art machine learning processes require three things: a sophisticated algorithm, a vast amount of computing power, and an almost unthinkable quantity of data. And so when we start this panel this evening, one of the things I'm hoping that we can talk through is the physical infrastructure that's involved behind AI. And with that in mind, I'd like to put it to you, Tom, having studied engineering and computer scientist. What do we mean when we talk about compute? Who's involved? What are the labor processes like? Where is this situated?
The compute, well, there's two bits of it, I suppose. So the hardware infrastructure of AI, what you just said, where you need masses of data, masses of compute, and a good algorithm, that's true for deep learning. There are other styles of AI that don't require massive amounts of data. So we should, as the previous panel pointed out, that AI is a collective group of techniques to try and get computers to do things that previously only humans could do. A self-destroying definition, because as soon as you succeed, it's no longer AI, it's just engineering. So autopilots in planes used to be considered AI, they aren't anymore. Anyway, moving on from that, I think what's interesting is the behind-the-scenes infrastructure is a lot more complicated than you might think. And as somebody once, I think it was Cory Doctorow, pointed out recently, AI quite often stands for absent Indian, because there are a lot of people behind the scenes in places like Kenya, in the Philippines, and in India who are doing a lot of the data labeling, who are doing a lot of the reinforcement learning through human feedback. In other words, try to make the LLM say something really dodgy and Nazi, and then say, no, bad LLM, don't do that. So there are a lot of people doing that behind the scenes. So yes, there is this gathering all the data, training everything for months on massive piles of GPUs to create a model. But then the model goes through this process of fine-tuning, where they try to control it and control its behavior, and get it to do things that are considered to be desirable by the creators of the model and not do the things that are undesirable. And of course, there's a whole argument about how you define those. So there is the sort of hardware infrastructure to it, but there are people hiding inside the machine, as it were, as well. This is I find quite amusing. One of my early books was about the Mechanical Turk, a chess-playing robot unveiled in 1770 that, spoilers, had a human hiding inside it. And kind of, AI is also, to some extent, a Mechanical Turk, in the sense that there are people instrumental in creating these things that we then go, oh, it's a machine.
I think on that, just as a little bit of a follow-up question, so one of the things you mentioned data centers, but you also mentioned chips. And I was just wondering, I know The Economist has covered a lot of this in some really fantastic detail in terms of the chip supply chain that's relevant to AI. And I talk about this in a panel on AI and us, because it's experiences like lithium mines that constitute so much.
Lithium is batteries, not chips. So, but what we're talking about here is the dependence. And when it comes to chips, we're all dependent. The whole world is dependent on the fact that TSMC in Taiwan makes the most advanced chips in the world. And it's a single point of failure for the entire tech industry. So the most advanced, the chips in our iPhones, the memory comes from South Korea, the cameras come from Japan, the processors come from Taiwan. They're, yes, designed in California, using ARM architecture. Hurrah, brilliant, Cambridge, hurrah. I'm a child of the BBC Micro. I love all this stuff. So there is this massive single point of failure. The Tesla chips that drive the cars, the Amazon AI chips, the Google TPUs, everybody is reliant, let alone all of the iPhone chips, everyone is reliant on TSMC in Taiwan, and no one else can make chips as well as they can because Intel dropped the ball. And Intel's like 2 years behind again now, and I think China is sort of 8 years behind. But there is a big concern that if there is a Chinese invasion of Taiwan, then that completely destroys the I mean, it has lots of terrible consequences aside for just the AI supply chain. But one of the things it does is it completely disrupts the tech industry worldwide. So there is that. And then there is the broader concern of lots of things. Solar panels, predominantly made in China. Lithium processing is predominantly done in China. Lots and lots of things depend on China and the supply chain. And if you move your manufacturing of iPhones like Apple has, some of the iPhones are now made in India, and some of the AirPods and things like that are made in Vietnam, but they still rely on materials and components that are coming from China. So in the event of a war with China and massive sanctions, and again to say, oh no, the disruption, the supply of AirPods will be disrupted is clearly not the main thing. But the point is that efforts to try and decouple Western supply chains from China they're much harder than they look, but they are underway because of this concern about the fact that there is this incredible concentration of chip manufacturing and then of lots of other things, chips in Taiwan and then other things in China.
Fantastic. Thank you so much. So we've started to develop a picture there to do with AI and the labor behind it. And I wanted to take this idea and bring it to you, Gareth, as someone who's worked extensively with the technology companies at the forefront of this kind of transformation. I was wondering, what do we mean when we say that powerful technology companies are behind artificial intelligence? Who are the companies? What are the decision structures like? Who's making the decisions at these sort of companies?
So I think, people use a range of acronyms, the FANGs, Facebook, Amazon, NVIDIA, Google, the Magnificent Seven, I think is the latest term that's being thrown around for some of the most sophisticated, large-scale technology groups globally. And, I think many of us in this room would have heard of some of the models, the Mistral models, Mixtral, that has been sort of made available on open source terms, the Llama 2, all these sort of letters and numbers, acronyms that throw out these different generations of models from Meta. So there's been this huge explosion in the last 2 years of proliferation of different models released by major technology groups. And it's been fascinating to see different business models. Meta, to take one example, in its release of Llama 2, has strategically made that model available on an open source basis, but with a technical restriction in the license such that, beyond a certain threshold, you have to take a commercial license, a fee-paying license for further use of the model. Other businesses have kept, and famously, OpenAI has kept many of its models proprietary, and so one of its main methods for making ChatGPT available is through what's called an API, an application programming interface, where enterprises that sign up to an enterprise license with OpenAI can, without getting access to the underlying weights of the model itself and underlying source code, the sort of secret source of how the model works, can still access the computing power and the output of the model through a secure interface. So the ecosystem, particularly in the last couple of years with the huge increase in computational power and the sort of widespread adoption since the release of ChatGPT 18 months or so ago, that we've seen this huge proliferation among enterprises, interacting with the technology groups, and clearly there's a degree of concentration of the most high-profile, high-power model releases within some of these groups, and so many industrial clients. Every business is a technology business these days. I think the CEO of Goldman Sachs said that many years ago, and it's become often quoted. But every business is a technology business now, interacting with the major tech groups, incorporating these technologies for productivity and efficiency gains. So clearly there's a huge focus on the most advanced capabilities within the Magnificent Seven, or whichever term one wants to use to identify that core cluster of significant businesses.
Fantastic. And I think perhaps in a similar way to Tom's point, one of the things that really came out of what you were saying there for me was often we will look at like particular clusters and the ways in which these debates are like nucleated in particular ways, but obviously the ramifications of this technology go far beyond that. And when you're saying like all companies are involved with this technology in different ways, it's about trying to frame a discussion about AI and us that tries to contextualize the ways the conversation is normally held within a kind of broader space. And it's, I suppose, with that sort of longer term perspective in mind that I wanted to begin our discussion today about the regulation and the policy, which is kind of why we're here to discuss, you know, how can policy help us live with AI, with a little bit more of a long view. And this is more directed to Dr. Grant, but you've worked extensively thinking about the long-term, the deep kind of philosophy of law, but also the ways in which that law might be related to AI more generally. I was wondering if you could tell us a little bit about how algorithmic and legal forms of governance might be similar and what implications that might have for helping us to understand the regulatory paradigm.
Yeah, thanks, Eddie. Thanks, Tom. Thanks, Gareth. One of the interesting things as a lawyer, and to some extent a legal historian, that comes to view when we think about AI, machine learning, is that in a very traditional understanding of what law is, we talked about law as a series of deductive operations, almost like running an old-fashioned computer program step by step. You read Blackstone centuries ago, and then judges and lawyers and law students 4 centuries read Blackstone. It was an exercise almost like mathematical logic, and I'm not making the analogy up. It's a centuries-old analogy. But in the 19th century, especially in the United States, but then it spread to Europe to some degree, jurists began to ask whether the deductive mathematical style logic really explains everything there is to know about law. And it was suggested, quite emphatically suggested, for example, by Justice Oliver Wendell Holmes Jr. in the late 19th century in America, that actually judges and lawyers engage in an inductive process, especially in common law systems like our own. And we look, as lawyers or judges or decision makers, we look at lots of data, actually. He didn't use the word data, he used the word experience, but they're both past tense concepts. They're about what we've seen before. And we find patterns, and that's a word that the so-called legal realists did use originally in the 19th century. They found patterns in past cases, and they then tried to express the patterns in a manner that was a fairly faithful reflection of the data, in the hopes that future judges would then agree with them and repeat the patterns. Now, there's something, if you think about that, there's something at least faintly familiar in what has happened in computer science in the last, especially the last decade. It used to be a type of mathematical logic. Do this, do that, and you get this result. But now it's driven, yes, you still have algorithms in that sense. Tom was talking about that as one of the physical pieces of the architecture. You need very clever ideas, and you mentioned it too, Eddie. But then you need these vast sums of data, and what do you do with the data? You find patterns. It's a turn toward induction. It's an inductive turn that we saw in legal thinking, and then we saw it again over a century later in computer science. Now, what is there to make of that beside, oh, gee, isn't that neat? I think it is kind of neat. It's the almost parallel morphology in how these two seemingly disparate disciplines evolved. But there may be some lessons as we think about the practicalities of regulatory response. For one thing, I think it's rather important that we have some intuitive understanding on top of some more detailed, Gareth's a guy to go to if you need to actually understand the nuts and bolts of this industry and how it interacts with compliance, regulators, enforcement, government. But the public at large, as we think of that social question that you frame the panel with, ought to have some basic gut feeling for what this is. And it's not recipe following, not strictly. It is important to get that inductive piece in your head. So I think that might, I know it's a terribly high level compared to the really much more practical and useful observations.
Can I ask, did law, presumably induction didn't replace deduction completely, it's a hybrid, right?
Oh, absolutely.
Because somebody made the point in the previous panel that what we actually want, and if you look at something like AlphaGo, the system that beat the world champion at Go, AlphaGo has two separate deep neural networks in it. It has a Monte Carlo tree search in it. So it's a mixture of what used to be called good old-fashioned AI, rules-based systems, and neural systems. And I think the whole bet that Demis Hassabis made with DeepMind was that the way you get to AI is by mixing these things up. Now, apparently, inside the company, they are now much more doubling down on actually deep learning can do everything. But we are seeing, I think the geometry system that they did recently that can solve geometric proofs was a hybrid system again. So I think, I don't think it's true that all computing turns into deep learning and our calculators stop working because you may have noticed chatbots are terrible at maths. There are times when you want to use the deductive and there are times you want to use the inductive. And there are lots of other styles within computing as well.
Absolutely, that's really well put. And if you're going to be a computer scientist, or if you're going to be a lawyer, you sure had better get comfortable arguing in a logical, deductive way. Or not just arguing, but doing things in a deductive way. You don't come to a judge and say, well, here's the pattern. No, you have to make a logical argument, and if you're going to compose code, you'd better have a logical framework in the way you express yourself. So, and it is a mix. In law, it's more a matter of contestation, and even ideological contestation, just what the balance is. I don't think there's a direct analogy between law and machine learning in that sense. There's nothing political or ideological as such about just what the mix is within DeepMind, whether these things do it all on their own or whether it's still something like old-fashioned programming. It's a technical question. So they part ways. But it's absolutely right that there's a mixture. And in fact, the logical or deductive mindset continues to be a very kind of the overall framing reference, because that's how you have to be able to express yourself if you're going to operate either as a lawyer or as a computer scientist.
Just invented explainable AI. But anyway.
Yeah, no, and these are all questions that we'll come back to a lot. But just to put this to you, I think, Gareth, in getting really into, like what you said, Dudgrun, into kind of the nuts and bolts of the legal paradigm that we have at the moment, I was wondering if you could talk us through a little bit about the legal paradigms that dominate your work, that you're most familiar with.
Yeah, so I think, on a high level, one could look back to, in 2019, the OECD, Organization for Economic Cooperation and Development, enacted a series of principles in respect of AI. And when you look at the architecture, the legislative landscape, which is what I do with clients, and we sort of hone in on very specific applications of the law to their business models. We try and look at the very top of the architecture and then narrow it down into real sort of granular applications under specific, applicable laws and jurisdictions. So, big picture, you've got OECD, AI principles, and other multinational principles, the Hiroshima process, G7 Hiroshima process, also, reached a conclusion on some principles adopted among the G7. And, those follow, core understandings that I think we can all be on board with. That AI should be safe, should respect the rule of law, should be human-centric, and ultimately intended for the benefit of humanity as a whole. And, should be transparent, should be fair. There should be redress. Those principles are baked into these multinational treaties and, commitments that have been concluded. So that, even back in 2019, and one could look even further back to, core, treaties, etc. You've got this sort of provenance of where we've got to most recently with things like the EU AI Act. Because what's happened, given the significant power of systems like ChatGPT and other generative AI systems that have proliferated on a consumer-facing basis, these systems are much more widespread and available to the general public than they ever were. I mean, AlphaGo is an incredibly powerful piece of technology, but its direct relevance to all of us in this room every day is not as evident as the way in which we can use ChatGPT right now to get a response. So what we've seen in the last couple of years really is very, very concerted regulatory focus on enacting more forceful AI regulation. That's been driven in particular by the European Union. And so the EU AI Act, which is close to being adopted and finalized, not quite adopted yet, but the publicly available text of that is all but final. That's likely to be enacted in the next month or two. And we'll have 6 months or so before certain provisions of that legislation become effective. The outright prohibition on prohibited AI systems under that legislation kicks in pretty quickly. So you're looking at quite a rapid timeline once it's adopted, and then 12 months and 24 months for various other provisions regulating things like general purpose AI systems, general purpose AI models like ChatGPT. So that's a very concrete legislative step that the EU has taken. That's horizontal. People often refer to that legislation as horizontal because it's sort of largely sector agnostic, and because it's an EU regulation, it's directly enforceable and applicable across EU member states. Right? There's some implementation, but it's by and large there's a high degree of harmonization, and it regulates anyone putting these AI systems on the market in the EU immediately. Now that EU, really, as they did with the General Data Protection Regulation, the GDPR, leading the charge in some ways, in respect of setting these very broad horizontal pieces of legislation as groundwork. The UK has taken a more wait-and-see approach, as has the US. People often say the US has a more sort of open market approach to regulating AI. We talked earlier in the previous panel, we heard about the UK's pro-innovation white paper. So the UK's taken a bit more of a cautious approach. Of course, we've got elections in the UK and the US this year. So in some respects, it might have seemed difficult to pass such critical legislation given the impact it has on all market participants pre-election. And I expect there will be quite a lot of momentum post-election to pass certain specific pieces of legislation, if not something very, horizontal as well. But so I think that's where we are right now. When you look at the US, UK, a little bit more wait-and-see approach. There are some very specific pieces of legislation that have been passed. In New York, there's an AI bias bill, a piece of legislation that affects recruitment and hiring and prohibits certain the use of AI in certain recruitment practices. In the UK, there's a kind of regulators have been encouraged to implement essentially a decentralized approach where individual sector-specific regulators like the CMA, the Competition and Markets Authority, the UK Data Protection Regulator, the ICO, look at the legislation that's within their sphere, their remit, and they seek to incorporate the AI principles into their enforcement of existing legislation. So that's a sort of high-level view of the AI landscape and how it translates into specific advice to our clients.
Fantastic. That was really clear and thorough. And I was seeing kind of, Tom, as you were saying that, it seems like there's a lot you agree with there. Maybe, hopefully, some things you disagree with. I was wondering whether you could frame not just this,
I
but
think that was a factual, that was an accurate description of what's happening. I think with there is a debate about whether So the British approach, which is called a pro-competition approach, which is basically do nothing, because if you did anything, it might get in the way. And it's not just in AI. We see this generally. In America, everything is allowed unless it's banned, and in Europe, nothing is allowed unless it's approved. And this is why you get self-driving cars in America, and you don't get them in Europe, because you're not allowed to do them unless you've explicitly got permission. So, and it's not just AI. I mean, this is true of most things in law, as I understand it. But I think the charitable way to describe the British approach is we already have laws that say make discrimination when you're hiring people against the law. So we don't need a new one that says if you discriminate using an AI, then that's bad too, because it's already bad. And so therefore we don't need new legislation, and we can just use existing laws and so on. And therefore we don't need to do anything, and that's very pro-competition, and please come and invest and build companies here. And we can be an AI superpower, rah, rah, rah. That's the government's position. The less charitable way of saying this is essentially, yes, that they are deliberately being hands-off, and we described the AI white paper as light touch. And we had a snooty letter from whichever bit of the government had produced it, saying, that's not, how dare you say it's light touch, pro-competition. And we said, well, the reason we used the words light touch is because it was in your press release. So that's literally how they described it themselves. But I think, while I'm being snooty about it, I do think that there is a danger of regulating too much too hard and sort of being too prescriptive. And if you look at the early drafts of the EU AI Act, they were trying to imagine all the ways that companies could use AI and then say what the rules would be for that. And of course, this was before ChatGPT was released. And then when ChatGPT came out, they had to basically throw the whole thing in the bin and start again, because they hadn't it was too much of it. It didn't fit into their framework. So as I understand it, they've got more of a principles-based approach now on things like accountability and transparency and redress and so forth, which I think is the right way to go. And I think that's the way we're going ahead. The analogy I like to draw is with cars. And we had this analogy in a slightly different way in the previous panel. When cars were first introduced in Britain, there was no speed limit, there were no driving tests, there were no seatbelts, there were no airbags. And the car industry would never have done any of those things if they'd just been left to get on with it. But so many people were dying in road accidents, particularly in the 20s, that regulation came in and it started to get tightened up, and you had to start doing things like having seatbelts, and well, actually they come much later. But it was driving tests, and it was speed limits and so on. And ultimately, the car industry was never going to spend as much in a free market on safety as society might have wanted. And so it was the right thing to have car-specific laws that said you have to do all these things. And you have to do things like, you can make any car you like and drive it on your own private land and kill yourself. That's totally fine. But if you want to drive on public highways, then there are certain rules you need to follow. And so you literally have to hand your car over to a regulator for it to be checked to see if it's safe. That's not a bad idea either. And people are talking about that's an approach that some regulators are talking about for AI, sort of pre-registration of models. China, funnily enough, does this. But the other thing that I think is interesting from the car example is that, yes, eventually you do need laws and a regulation that's specific to that technology. And I think we may get there with AI, but I don't think we're there yet. But the other bit of it that I like is, in this country, we have what used to be called the Transport Research Laboratory, which basically crashes cars into things and sees whether they're safe or not, and then says, maybe we should have new rules about airbags, or maybe we should have new rules about seatbelts or speed limiters or whatever. And they don't make regulations, they just recommend, and then Parliament can decide whether it wants to legislate. And I think something we could do with, either at a sort of European level, or we could do it in Britain or whatever, is a research body that is competent to test these models and look at them. And people often liken this model to CERN for nuclear physics. But if you have a body that's a bit like TRL, where you have competent people who can kick the tires on AI models and say, do we like the look of this? Do we have, that they can do safety and ethics work that the private sector is never going to do on their own. And I think, so I think the analogy with the way cars went from having no regulation to having really quite a lot of regulation is possibly quite a helpful one when it comes to AI. But I would be very interested to hear what our other two panelists think.
Yeah, maybe I'll jump in there first and then hand over to you as well. I mean, I think that's, the car example is a great one. And, a comparator might be that under the EU AI Act, as I mentioned, first of all, certain types of AI system are outright prohibited. Emotion recognition systems like subconscious manipulation are outright prohibited. But then there's another category of AI system, high-risk AI systems, which are just highly restricted in terms of the process by which you bring them to market, like regulation of the car industry today. And I guess the comparison might be, the vast majority of our digital and electronic products that we have in our pockets have to have a CE, or pre-Brexit would have had to have a CE mark on them, and they have to, when they're made available in the EU. And that CE mark indicates the safety of that electrical device, that's been tested. It's not going to short fuse and electrocute you. And so the AI Act, in its categorization of the risk profile of AI systems, said that there are certain types of AI system, if they're deployed into cars, like an AI system that detects an obstacle on the road and deploys an airbag preemptively, that's a safety component that has potential high risk result when it's deployed in a vehicle. So that sort of thing, along with various other things that are classified as high-risk AI systems, because of the use case of the AI system, it needs to be tightly controlled. It needs to be tested, crash tested. There needs to be adversarial testing to make sure it's secure, robust. The training data is
but that's done by the company, right? Am I right in thinking that the AI Act, like GDPR, is basically self-regulation? The companies look at it and say, under this law, for the high-risk systems, we are required to do more to prove to ourselves that it's safe. But there isn't actually someone from the government showing up with a clipboard and testing it. It's just we're in bigger trouble if we deploy a high-risk system without doing that testing. Is that how it works?
Well, the European Commission has established the EU AI Office. And high-risk AI systems will have to be registered.
Right, okay, so you do have to tell them that you're building a self-driving car, for
right,
example.
Exactly.
Yeah.
And then you've got to make available to the AI office and potentially to the public certain types of information about what you've done to test the security of your AI system.
Right.
And so what's really interesting about the original premise of the AI Act is it focused on the risks of deployment. What was interesting with ChatGPT was that we got into this world where actually with general purpose AI systems and models that started to hit the market 18 months ago, really, you now have had this question of, well, what is the risk? Actually, the corporations making those models available were not the ones who were determining the downstream use case. And that's where the regulation kind of all of a sudden hit the crossroads.
Right, because you can use it for a high risk, you can use ChatGPT for high risk things and low risk things.
Precisely. And so it threw open the legislation, needed a reset, because how do you regulate the risks of a general purpose system where actually the organization putting it onto the market, quite legitimately, huge investment into the computational power to generate these models. Ultimately, it's not necessarily their responsibility as to how those models are deployed downstream.
So how did they fudge it? This is what we're all now wondering, because they obviously had to come up with some fudge. And they also had to come up with some fudge that protected Mistral, because originally the fudge was LLMs are really, really bad, and you have to register them with us, and we're going to basically tie up all you big American tech companies in red tape. And then somebody said, yeah, but what about this French one that we want to be really good? Can you not tie it up with red tape? So what fudge did they do to solve that problem? Because I have to say my eyes glaze over when I try to figure out what's going on in that legislation.
Yeah. So no, it is absolutely arguable as a fudge, because it's the technology moves so quickly. How do you really pin it down? And the solution that was reached, the compromise that was reached, was essentially to obligate providers of general purpose AI models and systems to maintain a whole range of documentation, then potentially make available to regulators on inquiry about how they've developed and trained those systems. So that's pillar one. Pillar two, disclosure and transparency. So the providers of general purpose AI models and systems have to make available, or will relatively soon have to make available publicly on their websites, the training data. Not necessarily the data, the actual data itself, but a sufficiently detailed summary of that training data to indicate the provenance of the data governance and the curation and what actually went into the training. So that's a huge step from a transparency and disclosure perspective, because what it's saying is that we don't know necessarily the downstream use case, fine, but that we'll impose a range of obligations on you, the businesses making these systems available, to tell the market what the risks are. How are those tested? How are they ensured to be secure? And what is the training process behind those models, so that the downstream user has the capability to assess the risk?
Fantastic. Dr. Grant, any thoughts on that?
I do have a couple of thoughts. I mean, it's a really fascinating discussion. And one point is that we have, with data processing in its infancy, which probably depends on how you want to talk about it, but in the 1890s, a gentleman in America, Herman Hollerith, came up with a way to use punch cards to help with census data. And that was a pretty big step. His company was the forerunner of what became IBM, International Business Machines. And at each step of the development of the technology, I think there was a tendency, sort of like the tendency of the definition of AI to constantly cancel itself, to say, well, yes, you could use a machine to deal with that, okay, and with that, but all of the antecedents to the word that are very numeric and empirically pretty easy to understand as numerical properties. And there was an assumption that past a certain point, there existed, maybe still exist, certain things that are so intrinsically human that they will not be susceptible to numeric analysis or data analysis or anything like machine learning. But what we found, especially in the last 18 months with the deployments of these general purpose systems, is that surprisingly large numbers of functions that seemed utterly out of reach of some artifact are now either within reach or conceivably close to within reach. And I think in both your remarks, Tom and Gareth, it comes through very plainly that it's difficult to anticipate what's going to happen, partly because of the complexion of this technology as something that the end user will find use cases for, that the developer, the commercial promoter, probably didn't think of. And that multivalent aspect is pretty challenging to a regulator. Even with an automobile, you can surprise people. You can do really stupid things with an automobile that the regulator probably in the 1920s didn't think of. I'd rather not think too much about them myself right now. But an automobile is child's play compared to the machine learning systems that are now commercially deployed in terms of that unpredictability aspect.
A classic example with the car, by the way, is the Jitney business model of 1914 to 15, and the Jitney craze, which was it was essentially the Uber of its day. You'd be driving along in your Model T, and you'd pick people up, and they'd pay you a nickel, and you'd take them to work. And this was massively controversial because this was essentially unlicensed taxis, and they were charging the same fare as the tram system, so everyone stopped using the trams, and so lots of cities lost lots of revenue, and there was a huge hoo-ha about it, which looks very familiar to. But it was essentially a regulatory grey area about what you could and couldn't do with a car, which hadn't been anticipated, and it took this crisis to expose it, and so even with cars.
People around 1914-15 in New York City were getting hit by cars at a remarkable rate because they didn't know what to listen for. They could listen for horses and the clack, clack, clack of wheels on a carriage. They didn't recognize the internal
combustion. First person ever run over by a car in America, it was an electric car, because they're silent too. So yeah.
There we go.
Quiet,
there we go.
Anyway.
But that aspect, I think, is going to be really critical as we think about regulation and regulatory risk, the risks that may arise from regulatory response itself. It's a response that the public rightly demands its government to adopt in order to address truly felt risks. But every step you take, however well-intentioned and well thought through, especially when dealing with something as variable and hard to predict as these technologies, introduces its own risks. And that needs to be part of the thought process, I think, as we come forward with new regulations.
just have one additional thought on that, which I think is a really important point. You know, a lot of this we have to look at multi-jurisdictionally, because as much as we would like to control our own destiny legislatively, things like the EU AI Act have extraterritorial reach. So that's step one. They have extraterritorial reach because of the way they're drafted so broadly. But then also, any business trying to roll out these technologies in multiple markets hits a kind of lowest common denominator issue, or high watermark issue, I suppose, where, you know, as was seen with the GDPR, when all our inboxes were spammed with, you know, privacy notices, etc. Once you roll out digital products multinationally, you end up having to comply with the high watermark. And so there is a degree to which our hand is being forced in the UK, because we won't be able to be hands off for too long, because many of our businesses will have to comply with the AI Act, and so by definition will be trying to find the multinational level playing field for product rollout.
And then that introduces the possibility of a sort of first mover advantage in the regulatory space.
We've seen this before from the EU with with e-waste, right? So the EU introduced rules on recyclability of electronics before anyone else, and it became a de facto global standard because nobody wanted to run two factories in China, one for Europe and one for everyone else. So everyone adopted the European standard. And that's what happened with GDPR. No one wants to write their website twice, so we all get the cookie banner everywhere in the world. So this is what's going to happen with the EU AI Act, presumably.
Another point from Gareth, from your observation about the extraterritorial impact of the regulation, we should be thinking about the interplay cross-jurisdictionally. How does action in one jurisdiction affect behavior in other jurisdictions? How does it interact with law and regulation in other systems? It could just override the entire political calculus, so other systems have to adhere, but it also may interact in more complex ways. It seems to me another cross-cutting interaction that merits some thought is how one regulatory regime, even within a single legislator's jurisdiction, interacts with other regulatory regimes. If you say, do this in regard to the fresh water that you drink, but there's also a regulation about how you're supposed to hold your cup, complex etiquette, there might be hard to predict interactions between those rules. Now, back to the GDPR. You have this proto-explanation obligation. Actually, there's no clause that actually says explanation except one of the recitals, number 71. But Articles 13, 14, and 15 do say that you, as a data controller, if asked, and correct me if I'm bungling this, but you have to supply what they call meaningful information about any decision reached through a machine process. Now then, in an adversary setting especially, such as US court, and to some extent any common law court, if my client is demanding of the data controller meaningful information about a machine learning system's process by which it reached a decision that had some impact on my client, the data controller, the company with the data who ran the process, is going to give some sort of an answer out of respect for the court procedure. But in an adversary setting where the judge allows a great deal of back and forth and cross-pleading, I think I will then shoot back and say, fine, that's not really an explanation. I want you to dig deeper. And the logical reductio is, give me all your data. Not just a high-level layperson's summary of the data, because we're in an adversarial setting, we wouldn't be here if I trusted you. Show me the data. We saw something vaguely analogous in the Twitter imbroglio when Mr. Musk bought Twitter. It wasn't quite the same thing, but
I think we might see something like that. I think there's a good chance, I mean, it's a small chance, there's a 10% chance that Musk pulls Twitter out of the EU because he doesn't want to comply with the regulation. And we can see the same thing here. If the EU AI Act is deemed to be too draconian by American tech companies, they might say, well, no ChatGPT for you, because we don't want to have to comply with these sorts of rules and hand over stuff.
one defense that comes to mind for the data controller would be to say, though, we have masked the identity of people in our data set. We cannot take the mask off, because for us to take the mask off would be to violate privacy regime rights. Now, that's very speculative. I haven't seen an actual case of that. Maybe it'll never arise. Maybe that's the wrong tree to bark up. But it's an example of how you could imagine two regimes having these cross-cutting purposes. Give me the data. No, I can't, because that will put me in regulatory jail, so to speak, under the privacy laws.
That's if a European firm is sued in America. I think the more likely case is the other way round, where the American firm is sued in Europe, and it won't say privacy, because American firms never say that, because they basically don't have privacy regulation. But they would say, we're not telling you our proprietary secret algorithm, so they would, but it's still the same problem, which is the cross-cutting regulation. Yeah, so I'm sure those bun fights await us, and I look forward to them.
Just to hand that back to you guys, so I know Cleary, international law firm, you're dealing on both sides of the Atlantic. Has this come up? Are interjurisdictional issues kind of prevalent in your work?
Yes, certainly. Yeah.
Schrems too, right? Schrems too.
Schrems too.
Yep.
There's a political aspect to this, as we've seen with, what Tom's referring to is the landmark decision of the Court of Justice of the EU in respect of essentially data sharing between the EU and the US, and whether that's lawful unless you jump through lots of hoops under the GDPR. And there's been a political football there because of EU legislators' perspectives on US the security and surveillance rights that exist or existed to an extent in the US. And so, there's a geopolitical aspect to this. But then, where I see these multi-jurisdictional issues the most is in respect of intellectual property and IP law tussles between different parts of the economy. And what's very challenging there and very interesting is the fact that different jurisdictions have taken a very different approach to balancing the interests of content rights holders and creators and the rights of technology groups who are pioneering these very powerful, very promising, high-impact technologies. And that is a difficult balance to strike, right? And it's something that I'm sure people in the room will have a view on. In the previous panel, we talked about some of the debate about the interests of employees and workers and how to balance those rights in respect of technology like this. And similar debates are springing up around the world in respect of how do creators ensure a degree of remuneration. What is the fair remuneration for works that are created that are in some cases then learnt from by the developers of AI systems. So in the US, there's a big debate about so-called fair use, the fair use paradigm under US copyright law, which is essentially an exception from copyright infringement if you can demonstrate that it's so-called fair use under the sort of legislative construct and court construct in the US. In Japan and Singapore, legislation has been enacted to allow what's called text and data mining, essentially, the extraction of content for training AI systems on a commercial basis without needing to, remunerate the rights holders of the content. Now, that obviously has some significant advantages for those developing AI systems, because clearly, depending on the type of system you're developing, it's impossible to go and seek consents or enter into license agreements with, like the world. If GPT-4 trained on the internet that's publicly available.
And lots and lots of books. So two of my books are in the training set, and there are a bunch of authors who are suing OpenAI saying, you use my book. And I don't know where I stand on this, because on the one hand, people read books and you can just say, well, the AI basically just read it. It hasn't memorized every word of it. But on the other hand, it's like, well, you didn't ask, so that's not on. So yes, you can imagine lots of people moving to Singapore to train large models in order to escape this possible legal pitfall.
Right. But we see we don't have any equivalent exception in the UK. It was debated up until as recently as last year as a potential legislative reform to have a commercial text and data mining exception from UK copyright, and that was withdrawn by the government. So clearly there's continuing debate, but the problem is you have to take a multi-jurisdictional perspective, because if you can train AI systems in Singapore and then distribute the resulting AI models to other markets, it matters less what UK law, what European law says about the rules around copyright and the ability of rights holders to enforce copyright against the input data, the input content that is in some cases used for training large language models.
Fantastic. And as you were speaking there, I know, Tom, so you not only kind of work in journalism, publishing, but have published books yourself. I was wondering, as we start to look, maybe turn away from regulation to kind of the social and societal impacts of AI. And Gareth, you raised publishing there as one area you were kind of thinking about. I was wondering if you could speak a little bit about how you think that the copyright debates and IP laws affected by AI interact with how you work, and what you think about the general implications for generative AI misinformation causing kind of your line of study.
Yes. Can I just say, though, it's really great that we're talking about these crunchy things that are real. Real laws, real dilemmas, real problems are going to arise. Nobody has mentioned killer robots. Nobody has said, oh, but are they really conscious? This is brilliant. We have avoided the usual bullshit traps of AI panels. So I would like to congratulate my fellow panellists for this.
I'm crossing things off as you speak.
Brilliant. So let's not have any talk about that. Yeah, exactly. It's such a waste of time talking about killer robots. We're not going there. And paper clips. Anyway, yeah, well, unfortunately, I've mentioned them now, but in a negative way. But no, I mean, this is a very small. There is obviously massive societal implications for what you could do with AI, and what happens to the publishing industry is not, the one that I'm most worried about, even though it's where I work. But yes, there are. I mean, it is, as has been pointed out, it is a specific case where, with these large language models, they need to chew on lots of text. They've kind of run out of text to read. They've read the whole internet, and so we're now going to be scanning like all the books ever written, all the journals. That's all happening, and the people who have that specialist data realise that this is something they can sell to the company. So if you read Elsevier and you've got a massive load of scientific journals, then you're like rubbing your hands going, either we can build a big AI ourselves or we can sell this to someone else who can. And we're starting to see deals where so Adobe, for example, its Firefly generative AI image system, they licensed a whole load of images from stock libraries, because stock libraries are suing makers of other generative image models because they've basically used, they've used all these photos, they've used lots, you can say, give me a drawing of this in the style of Picasso, but you can also ask these models to give you stuff in the style of living artists who are, not surprisingly, a bit hacked off about this. So there's a lot of kind of quite interesting legal bun fights going on there, and I don't know where that's going to be resolved. And just to answer your point directly on journalism, one of those is that many publishers are negotiating with the large companies, or in some cases fighting with them in the courts. So the New York Times has sued OpenAI, which has clearly used a lot of New York Times articles in its training set, and in some cases seems to be able to regurgitate them verbatim, and so New York Times is suing. So there's quite a lot of this sort of argument going on already.
I'll just add, a tremendous amount of ferment right now in the litigation setting in courts in various countries over IP issues, and one area among many will be defining boundary between copyright and patent. And you have a High Court decision just in November, this Emotional Industries against the Patent Controller, in which the scope of what is patentable, as distinct from what would be under copyright, as distinct from things that aren't under either, that was very much in the center of the litigation. continue to be an area where parties are calling on courts to work out the details as time goes on, unless you simply instigate legislators to step in and lay down the law, so to literally lay down the law and make new definitions for these technologies. But what I thought very interesting in the November, this emotional industries Ltd, I think, you see a...
Oh, this is the guy who says his AI invented something and tried to patent it.
That's a slightly different
Is that a
case.
different one? Okay.
That's the Dabus.
Oh, that's down. Okay,
Thaler.
okay, right,
That's Thaler. That's
okay,
Thaler.
what's emotional industries doing then?
Well, the issue there is whether, when you go from the machine, the algorithmic aspect, the deductive logic aspect of a program, when it produces the weighted system of nodes in an artificial neural network, is that thing a program which doesn't fall within
the model? Right. Yeah.
UK law has an exclusion to patentability. Once again, step in when I get this wrong, but the exclusion encompasses traditional programs. You don't patent programs.
Software as such isn't patentable, but there are obviously millions of software patents globally in the US, in the UK, but the software as such is not patentable, but you can have a technical effect expressed through software, and what you're patenting is really the technical effect.
And it would seem that
because the technical effect can also always be produced by hardware because of like universal computing principles. So a good example would be 3G and 4G systems use CDMA algorithms to spread stuff around, and that is a patented system. And I've never really been sure where the line lies between that sort of thing and quicksort. So my tutor at Oxford invented, or did he discover, the quicksort algorithm, the fastest linear computer sorting algorithm. He didn't patent it. Could he have done? I don't know. I don't think he should have been able to.
Yeah. Well, but see, this is the debate: is where should we draw the line? Copyright, patents, the IP debate centers around what is the interest of society, and where do the economics flow long term in respect to these incredibly powerful, incredibly useful inventions. From a copyright perspective, one could look at the music industry and look at streaming, Napster and the effect that had in the 2000s, then its sort of replacement really by Spotify, and that caused a complete reimagination of the economics of the music industry, where a £15 CD from HMV was replaced by HMV's like now long defunct, so some in this room might not remember that, but it's replaced by 0.0001 pence per stream, right? And that whole new economic model had to be created through heavy negotiation and litigation before it was settled on, and it's still evolving. And one could look at AI in a similar way. How are we going to construct systems within advanced economies or economies all over the world to actually deal with, to incentivize creation, step one, to incentivize Tom to write more books. Tom needs fair remuneration for his literature. But then, on the other hand, there's a debate around restricting, or things that could potentially restrict, the advancement and the availability of these technologies if some of the processes behind them are essentially to just enable advanced systems to learn how to construct outputs, right? So a lot of this is about knowledge creation within advanced computer systems, and just because it's been trained on the internet doesn't mean every single person whose data is on the internet needs to receive 0.0001 pence, because that's not economically efficient.
Dr. Grant, did you have thoughts to add there?
I think it would be very sad if the whole thing came to a halt, because you have to give 0% to every person whose book was used in the training process. But that might not stop the suits. and it's not necessarily a forecast of what the judges in different jurisdictions will decide. I don't know. It's a really fascinating problem. One suspects that the tremendous value that has been generated by this technology will move regulatory and legislative response if it came to pass that too many judges went down that road and got in the way of it. One suspects that that's what would happen if you started to see too many courts doing that without higher instances overturning them. And then there'd be this age-old colloquy between the legislator and the judge. It's not a formal thing where they send letters to one another, but they do very much concern themselves with one another, and then the judges would get it, even if they're not explicitly instructed to get it. It'll be very interesting to watch.
I realise I didn't answer your question on misinformation. Very quickly on that. Misinformation is a mistake. Disinformation is deliberate. That's the important thing we have to remember. Obviously, you can make misinformation and disinformation much more easily with these systems. But I would say, look at what happened with social media in the 2016 election. Two things. Firstly, people clearly will believe lots of stupid things without AI. So even if you found if I had a magic wand that I could wave it to make AI disinformation go away, you'd still have to solve the problem that people believe stupid things. And there are other solutions that you need to. There's no silver bullet for that. There are lots of underlying reasons why that's the case. That's the first thing. The second thing is, in the case of the 2016 elections and the impact of the role of social media in steering the output of that election. The fact that there were attempts to do this only became apparent afterwards, and to this day there is no consensus on whether those efforts made any difference. The big thing that made a difference was that Russian hackers stole the DNC emails and then got Julian Assange to leak them at a time that was beneficial to Donald Trump, and that was the main, as far as I can see, main way that Russia intervened in that election. They may have been doing clever things on Facebook, but the really interesting thing is that even today there are people who will tell you it didn't make any difference. So I think as we go into this biggest election year in history, there is undoubtedly going to be this kind of thing. In fact, there have already been examples of it. But I would say, firstly, that it may not make as much of a difference as you might think. And secondly, there will probably never be a consensus on whether it has made any difference or not, because we've had years to figure it out with the 2016 election, and we still haven't.
1932 was a pretty big election year, but be that
not as big as this. So this year we've got 70-something national elections, total population 4.2 billion people. That's more than half of the world population for the first time in history, although some of these elections are more democratic than others.
Big in one way, but
biggest ever.
Just to pause it there, speaking of democratic participation, just had a note that now might be a good time. I know it feels very much like we're in the thick of things, but I'm sure this could go on for many, many more hours. To open it up to the crowd. So I'm just going to start with, if you want to ask a question.
Well, I've given some thought to that, but I think, Gareth, you will have as well. I mean, you're in a large legal service providing organization.
Employment of legal clerks is going up, isn't it?
Yeah.
Because discovery is easier with data, and you need more people.
Yeah.
But you need different skills.
I also have a gut feeling that you could see a return to to an earlier model where the actual lawyering is absolutely critical, and that's what the focus would be on. In the sort of mid-20th century to the almost present, you needed huge numbers of very junior people, and that was a good business model for people in partnership in large law firms. But it's not how it was 100 years ago. The people who were at the bar or were solicitors at that time were mostly, they had to really be able to do classic legal argument. I think you could imagine if machines start doing a lot of the more rote functions, that the legal profession isn't going to disappear. It's just going to look, ironically enough, very old-fashioned. Lawyers will have to actually be the people who can think on their feet, and also think in a lawyer's fashion.
We're going to need a lot more of them, though, because we've just been talking about all these coming legal fights. It sounds like a bonanza for lawyers. AI is going to be brilliant. Everyone's going to be suing everybody else. The lawyers are going to be the only people who win.
If that's the case,
Gareth.
then, I think, legislation is backfired. Yeah. But it also makes a great career choice if that's what you want to pursue. So I completely agree with everything that's been said. I think AI will be an enabler. It'll change the skill set across many professions and many types of work. But the fundamentals, the sort of knowledge and the expertise will remain valuable. But what it will do is mean you won't be sitting in a data room, wading through loads of boxes as part of a due diligence exercise, because a lot of that actually work should get a lot more fun, because you're not going to be getting like a million paper cuts poring over board minutes, as a junior lawyer.
I think that's absolutely right. I can't say absolutely right, but I think that's really plausible. I think it's already happening. Discovery now involves running basically AI queries on massive troves of data. So it's a different thing, but it's kind of the same thing. Anyway, enough law. No killer robots for lawyers. I don't think so, no.
Killer robots for lawyers. Grab first.
Yeah, this is a bit of unknown to me, but I was very interested to hear how the EU AI is created for ChatGPT, but had to get rewritten again because all the assumptions changed. I guess, and it sounds very detailed at the time for specific scenarios. So how feature-proof is it? I mean, are we in a situation where, say, 2 years down the line, this has to be rewritten, and what kind of mechanisms can we incorporate into this legislation so that it's not constantly outdated, right? I guess how can we go about whilst it not being so vague that people don't know what to do and how to act around it?
Yeah, I think it's a great question. I think they've tried to make it as future-proof as possible because it focuses on the risks. So there are parts of the legislation that will be able to be updated, including the list of high-risk systems, so that as particular use cases evolve and become known to be risky, we can add additional things. But clearly, it's an imperfect model, and it'll have to be reevaluated in probably sooner than we think. But I think you're absolutely right. It's very difficult to legislate for this stuff, but they try and future-proof it by focusing on impact, and then for the things that are general purpose by just requiring lots of disclosure, so that everyone knows what the risks are.
There's another question over here. Woman at the back.
Yeah.
Can I take the explainability one before we get to that? That sounds great, by the way, but it means you need to
It's a great question.
Yeah, both brilliant
both
questions. I think on the explainability front, I think you've really put your finger on something very important, because the computer scientists have said, well, this is unexplainable or we can't do it. And then the politicians go, well, you need to make it explainable. And I'm reminded of what happens with end-to-end encryption, which is where the security gurus say, well, you have to pick end-to-end encryption that's completely secure, and the politicians go, yeah, but put a backdoor in it, but just for the good guys. And the computer scientists all just go, oh, God, there isn't a way, you have to pick one. It's either secure or it has a backdoor. There isn't and I don't think that one is fixable. And there is ways you can put, on device, you infiltrate devices and blah, blah, blah. And we have a similar problem with this. What I think is good, though, is that this puts legislative pressure on the developers of those systems to find ways, it basically incentivizes them to spend money on explainability that they wouldn't otherwise have spent. And there's been some really interesting work on this just in the last few months. I don't know if you've seen essentially, if you crash an LLM into an AI that does other things, it's really a multimodal AI. But my favourite example is from Wave, with a Y in the middle, which is a self-driving car startup in North London. Microsoft's a big investor. It's trying to build kind of Android for self-driving cars. It's very impressive. It's all camera-based, no LiDAR, and I've been in one of their cars. And by the way, it did roundabouts really well. And it drove around a photo shoot, which had been coned off, and it was very, very clever. And one of the things about that system is that they have built an LLM into it so that it can tell you why it's doing what it's doing. And you can literally ask the self-driving system through a chatbot interface, why did you slow down? Why did you do this? Why did you do that? And so it gives you a way of adding explainability through these multimodal systems. That's really interesting if it works. Now, of course, what immediately happens is people say, well, was that really why it slowed down, though? It could be lying to us. But the interesting thing about that is if you put someone in a court of law and say, what was going through your mind when, or why did you do this? You are in the same position that people are black boxes too, and they may say why they did something, or anyway. So,
and to jump back to the seemingly very abstract legal analogy that I made earlier in our discussion, it's a classic observation of the legal realists that the judge, though very practiced in giving logical reasons for the decision handed down by the court, might actually have been thinking something quite different from what's in the printed judgment. There will be unstated premises that shape the judge's decision. And that's a reality of legal life. And now it sounds like we have another parallel, possibly, in machine systems, where the explanation might or might not be completely trustworthy.
So what does that mean we should do with the self-driving car? When the self-driving car says, I slowed down because I thought there might have been a pedestrian behind that ambulance, how do we prove that that's really why it did it? So it's just pushing the explainability problem into a different place, right? Anyway, I think you're absolutely right. And what I hope will happen is that this will mean that the big companies have to spend money on explainability because the EU could come knocking at some point and say exactly why did this system make this decision. And it may also push us back towards these hybrid systems that are combinations of neural systems and more rule-based systems where it's easier to understand what they're doing.
And just to jump in there quickly, just because it would be probably remiss if I didn't say, so one of the things the Centre for Future Intelligence has been working on in the last couple of months is what do we do whilst explainable AI catches up to state of the art? And one of the answers, actually in a paper that came out on Wednesday by Dr. Hayden Belfield, among others, was talking about a framework called compute governance. So it's not really my area of expertise, but it's a great and growing field of how we make sure that there are restraints on these models that set the space in which this explainability work can be done. I definitely recommend checking out compute governance paper. Handing it back to you guys for the second part of the question, artificial inventors.
Yeah, no, I think, look, this goes back to the question of what role does IP law serve? You know, and law as part of the fabric of society and the ways in which we, you know, I think the whole topic of this panel is, you know, AI and us and AI and ethics. You know, what is the code and the rules by which we all go about our lives and so the rules of the game in terms of, you know, incentives and remuneration. And IP law is there largely to incentivize creation so that you get a fair economic return for your investment, your time investment and your creation. And to, you know, protect, you know, enable you to enforce those rights against third parties who don't pay. So when you look at the patent legislation, if one were to take the view that AI outputs could be patentable with a very low bar to novelty or inventive step, you would potentially have this mass proliferation of patents for inventions of questionable contribution to the state of the art, which is what the patents are there to largely incentivize and remunerate. And also a patent right is an exclusive right, with a 20-year term in many jurisdictions, which is a pretty long time horizon. Not so long in the pharmaceutical industry, because you need 10 years to go through clinical trials before you can show a medicinal product is safe. But if you can get a patent for an AI output, with a very low bar to novelty or inventive step, you can see how that would have an economic impact in the way in which in notional inventions are then give monopolies to businesses.
But of course, isn't that an issue about the existing framework of patent law and how we measure whether a new artifact is amenable to patent? In other words, that may not be intrinsically linked to the case of a machine producing something genuinely novel and interesting. We apply the ordinary test. I'm being a devil's advocate.
You're right. Patents is bullshit already. I remember talking to someone at Nokia, and it was like Nokia filed 5,000 patents last year. Huawei filed 8,000, and the guy at Nokia said, "Yeah, but when we file them, we're like, how many would you like? We can make this 5,000. We can make it 10,000. It's we can chop them up basically. I mean, it's nonsense now, and so actually what we've concluded is that patent rules need reform. This is Ken. This is one of your things. So yes."
Could I also just tie up what I think might be, sorry, but what might be a little bit of a loose end? Patent, as a matter of policy, certainly performs an incentive function, but it also performs a function connected to the meaning of the word patent, which is open. It's about publicity. It's about saying to you, don't keep your great idea secret, which you would do if you have no protection for it, because the only way to profit from it then would be to keep it secret and then mete it out drop by drop to the market. But instead it says, put it up in bright lights so the world knows with whom to transact. You. By making it patent, not only do you get, what's a bargain? The bargain is, we the government protect you from theft.
SpaceX has not patented any of its rocket technology. It prefers to just keep a secret.
Well, it's always a choice. That's right. Trade secrecy and patent are nodes on a sort of continuum. Yeah, a dichotomy. It's yes, absolutely.
Yes.
Bingo. And don't just believe the gentleman in the tie, because I heard the rumor that the general counsel of one of the mega big tech companies once referred to efficient infringement, by which he meant we just take it and use it because half the time we win in court, half the time we lose, but we can afford to lose occasionally.
But there have been instances of...
Rationale for the IPR system has two roots. So one is the moral and ethical rationale, but an AI
mean, I don't see that necessarily as a bad thing. You know, if I create some new mechanical device, I'm a human inventor, you know, did it myself. Maybe I use AI as an enabler to help me construct certain parts of that technical device, but ultimately I did a lot with the output that was original that I did, you know, through my expertise in whatever industry. I apply for that patent, and if there's a huge backlog of patent applications, if what we're talking about when we say AI is essentially just advanced technology scanning, you know, the 10,000 other patent applications and the whole range of other existing patents to see what the existing state of the art is, that's just you know, an efficient way. I mean, ultimately, if the patent's challenged, there'll be human intervention.
Sorry, just to drop in, just because I think we've got time for one last question, and there may be a member of the audience who aren't experts on patent law. I think we had one question. Did you have? Oh, yeah.
Yeah, I think it's very hard to imagine how a pause would work. I know we had the letter last year calling for a pause. It was Elon Musk's idea. He was starting a startup, and so 6 months of everyone else downing tools would have suited him just fine while he spun up his own startup. So he was somewhat had a conflict of interest in that one. Yeah, it's very hard to imagine how you would check that there was a pause going on, and obviously not everyone in the world would obey it, and there would be some of this jurisdictional arbitrage that we've heard about, and Singapore or someone would say, actually, we're not having a pause, everyone come here, or China would, or so. I don't think that's going to work. Going back to the analogy question, I think the main takeaway I have from this panel, we've used a lot of examples of previous internet technologies and previous internet debates, whether it's GDPR, whether it's the way that we've thought about thorny problems that have arisen on the internet and what that means, and the sorts of arguments we've had about internet things. And I think the best way to think about AI and the need to regulate it, but also its long-term impact, this sort of answers the question you asked earlier, is to analogize it with the internet. Because if you go back to the 1990s, there were people saying that the internet was going to lead to world peace and abolish poverty, and then there were other people saying it was a fad and it was our generation's CB radio. And neither of those things turned out to be true, and it did actually end up being something that we all use every day. But at the same time, it wasn't as terrible as the critics said, and it wasn't as wonderful as the boosters said. And I think the same is true with AI. We're now told that it will either make us immortal or the killer robots will come and kill us all. And I'm afraid the boring reality is it's somewhere in the middle, like the internet. It's a tool that you can use for good things and bad, and the goal of policy and regulation should be to emphasize the good things and make it as hard as possible to do the bad things. That's been the story of internet regulation, and I think that's going to be the story of AI regulation as well.
And maybe to get just some final words. So I think, Tom, those were really...
Those are my final words.
Those are really powerful. Gareth and Dr. Grant, I was wondering whether... Let's imagine we're back here at the panel in 3 years' time, and we want to know what's changed. What did we get right? What do you think we might have got wrong? Any final words from you guys on that? That's a difficult question, I know.
I think the big question, I'm not sure whether it'll be right or wrong, is how we've reacted to movement like the EU AI Act. What have we done in the UK? How is that compared to what's done in other major markets? And where does that leave us as a society in terms of how we incentivize labour and value creation?
Dr. Grant?
I'd like to think we've left ourselves a wide enough margin that we could probably argue 3 years from now that we didn't get anything terribly wrong. I think one of the most important observations we've made is a lot of this is in flux right now, and there are challenges in adversarial settings, but also in collaborative settings within companies, within legislatures, and in society at large to wrestle with the problem. And the problems are themselves unpredictable because the technology surprises us again and again. 18 months ago, it was quite a remarkable thing to see ChatGPT for the first time. I think most of us who've witnessed it were surprised the first time we saw it. You could maybe, oh no, I saw it coming. Fine, all right. I'm reminded of the Trinity fellows who in the 90s were asked to put the internet in the rooms of the students, and they said, oh no, actually, we tried that in 1927, and you see it didn't work. It's an old Trinity joke, sorry. But it's that sort of thing. Of course, no, we didn't try it in 1927. Nothing like this existed. It is truly novel, and it's truly different in important ways. And so for that reason, I think we've from Gareth and from Tom, I think we've heard really helpful suggestions of the parameters in which these issues are being both contested and collaborated on.
Fantastic. And unfortunately, I think that wraps up all the time we have today. I'd like you all to join me in a big hand for our panelists tonight. Thank you so much.